And your name, sir?
David Walker.
Your Honor, it looks like he has two files.
I see that. All right, we'll next take up two cases, both entitled State of Kansas versus David Wayne Walker, 22 CR 398 and 22 CR 508. All right, we'll first take up 22 CR 508. This is my case, Mr. Walker. You failed to appear in front of me on July 17th for your preliminary hearing control docket. Where were you that day?
It's safe for sure, sir.
Today, we are going to watch a masterclass in confusion spiral into a legal train wreck. The judge opens court, calls David Wayne Walker's cases, and spells out how he skipped a critical hearing, triggering a bench warrant and a fresh $10,000 cash or surety bond. Instead of grabbing the lifeline of an experienced attorney, Walker calmly insists on representing himself, politely declining real help as the judge double-checks he understands the very real felony stakes he's playing with today.
Okay, well, I issued a bench warrant bond forfeiture and set a new bond in the amount of $10,000 cash or surety. Are you still representing yourself?
Yes, sir.
You want to continue representing yourself?
Look at me. I'm not looking at you. I'm looking at the paper. Yes, sir. Don't have any money to.
Pardon?
Yes, I guess I'll represent myself.
Okay, you understand that if you can't afford to hire an attorney, one would be appointed for you.
I don't know what he would do for me.
In this segment, the system slows down to protect Walker from himself. The judge and clerk comb through the record and realize he never properly waived his right to counsel, even though he once claimed he hired a lawyer. Now, under oath, he's formally waiving that protection. The judge has the jail hand him a waiver form, instructs him to read it carefully, and calmly stresses that this paper will later prove he knowingly chose to face felony charges alone, without professional defense.
Okay, well, he could provide you legal advice and perhaps advance any defenses you may have had, but if you want to represent yourself, you have that right. I just want to make sure you understand that if you can't afford an attorney and would like to have one represented you, I would appoint one for you. Do you understand that?
Yes, sir.
And you wish to continue representing yourself?
Yes, sir.
The docket notes don't reflect if a waiver of counsel was ever signed. Do you have any notes that would reflect that he's waived counsel on the record or otherwise, Ms. Norris?
Your Honor, I just note that on December 30th of 2022, defendant stated that he would hire his own counsel, and then he had a failure to appear, and on May 5th, we did not appoint any counsel. I don't show an actual waiver, and the notes don't reflect that he did a waiver on the record. It just says that he would hire his own attorney.
Okay, well,
Okay.
Mr. Walker, you've indicated here on the record that you wish to waive your right to an attorney and represent yourself. So I'm going to have you, if the jail has one, sign a waiver of counsel. Do you have a form?
I believe so.
All right, can you read through that? Make sure you understand it. If you have any questions, be sure to ask me.
There's
Yeah.
no defendant in the. I'm the defendant in the case. Am I the defendant in the case?
Walker's confusion shift into full sovereign citizen mode. Staring at the waiver, he suddenly questions whether he's even the defendant, as if saying the magic words might change reality. The judge bluntly confirms it, while the commentary points out the obvious clues: orange jumpsuit, tufts, and concrete walls all around him. Then Walker pivots to his favorite mantra, insisting there's no victim at all. The judge answers with real charges and real law, but Walker clings to fantasy over fact.
There's no victim. There's no victim to my crime, correct? The crime that I'm accused of, there is no victim in the crime.
The state of Kansas, you have drug charges, possession of methamphetamine, possession of paraphernalia, and driving while suspended are your 3 charges.
Yeah, but no victim, correct? No victim in the crime.
What's to do with your waiver of counsel?
Well, I'm the defendant. There must be someone making a claim
The state of Kansas is making the charges against you, Mr. Walker.
the state of Kansas is the victim.
The state of Kansas charged you with these crimes. Do you wish to represent yourself, or do you wish to have an attorney representing you?
I will represent myself.
The direct clash between courtroom logic and pseudo-legal mythology. Walker keeps insisting that crime requires a flesh and blood victim, refusing to accept that the state of Kansas stands in for the public as the injured party. The judge lays out a school zone speeding scenario to show why laws exist before a child gets hurt, not after. Even with that crystal clear example, Walker stubbornly reaffirms self-representation, digging himself deeper into a hopeless legal strategy.
Got a waiver of counsel in front of you, correct?
Yes, I suppose so. Why do I need to sign? Why do I need to sign it? Why do I need to sign this?
Because I like to have it documented in the file that you understand that you have a right to have an attorney representing you, and that if you can't afford to hire one, one would be appointed for you. And you understand that, and knowing those rights, you wish to represent yourself. That just documents that for the court file.
What I don't understand is why there is charges against me when there is no victim.
All right, Mr. Walker, I'm not going to play this game this afternoon. I'm going to set this case
Why are we playing a game?
in front of me on.
I'm asking a question.
We watch the judge's patience finally start to erode. Walker circles back yet again to his no victim argument, and the judge shuts it down, stating he won't play that game in his courtroom. He sets a firm felony preliminary date by Zoom and reminds Walker about the $10,000 bond looming over his release. When Walker vaguely asks for access to people and things to help his case, the judge points him toward the jail's law library, a thin consolation prize compared to a trained defense
Walker,
attorney.
your case is being set on October 10th at 2:30 in front of myself, and that will be done by Zoom. That's the felony preliminary hearing control docket, October 10th at 2:30.
Your Honor.
You've got a $10,000 cash or surety bond on that case.
Yeah. I was wondering if I would be able to have access to certain legal things to be able to.
I believe they've got a law library there at the jail. I'm
Oh,
not
they
sure
do?
what kind of access they provide to you, but you can consult with somebody there at the jail.
Okay.
All right, I'm now going to take up 22 CR 398. This is Judge Webster's case. Looks like you failed to appear in front of her on July 31st. She set a new bond for $6,000 cash or surety. You've already had a first appearance, so I'm going to set this in front of Judge Webster on October 30th at 9 o'clock in the morning. That will be by Zoom, October 30th at 9 o'clock in the morning. So again, your bond is 6,000 cash or surety. Anything else on this case, Ms. Norris?
No, Your Honor, thank you.
Your Honor, was the time for court on October 10th for 22 CR 508, was that 2:30?
That's correct.
Just clarifying. Thank you, Your Honor.
All right, we'll be in recess. Mr. Walker, you are excused.
Stretch. The court turns to Walker's second file and the pattern becomes impossible to ignore. Another missed appearance, another judge, and now a separate $6,000 bond plus a new Zoom court date on the calendar. After confirming times and judges, the session ends and Walker is excused, still no closer to understanding what he's facing. The commentary signs off with a jab about recess, then reminds viewers to like the video, subscribe to the channel, and we'll see you in the next video.